Hi there and welcome to today's video. Today I'm going to be focusing on the steps that creditors can take, and I'm using the Rudy Giuliani case as the perfect example because it's being reported in the news. Actually, he posted it on Twitter saying that they seized his bank account. Now, the funny thing is, if you look up the tweet, it says I think he didn't say prohibiting, but basically they're prohibiting him from earning a living. I don't understand the connection. What does your checking account have to do with earning a living? You can earn a living. They're not saying you can't go to work. They're just saying they're creditors and they have the right to seize whatever assets he has. Now, let's talk about prohibiting his work. He has his coffee line, right? I'm sure he gets paid for appearances. He's not doing that for free. It's common to get paid if you go to a convention or anywhere else that he does speaking engagements. And when he had Chapter 11 bankruptcy and he dismissed it. And I'm going to get into that because I have my phone in my hand. I had to save the quote because there's just so many things to go over. But during his bankruptcy, he promised, or at least stated to the court, that he would reduce his expenses to $43,000 per month. Think about the number I just said. How many of you make 43,000 a year? And yet people are donating. If you see his Twitter feed, they're actually donating, which doesn't make sense to me because isn't that a form of entitlement? Hey, go ahead and send me this. Now, here's the part, and let me slide over here on my phone because this is the part that gets interesting. The defamation lawsuit, there was no dispute as to the statements that were made were defamatory. There was actually a stipulation entered in court agreeing to that. And I have it here saved and actually put in a prior blog post. I'll put all those links below. It says, I hereby declare pursuant to 28 USC 2201 as between plaintiffs and defendant that defendant's conduct was intentional, malicious, wanted, and willful, and as such plaintiffs are entitled to punitive damages. That's the key. That was actually agreed to in a judgment. They are basically saying, so Giuliani and his lawyers are saying they are uh, what is it, Ruby Moss and Shay Freeman? I forget their names. Sorry about that. I'm horrible with names. They are entitled to punitive damages, basically punish him. Now, was there a trial? No. Did they have multiple hearings and try to resolve it this way? No. I don't even think an answer was filed to the complaint. Typically, you file an answer denying just about everything. This was agreed to. So the only issue was how much? How much is this going to cost? So the bottom line is he gambled and lost. And so now the consequences is I'm going to file for bankruptcy. I'm going to get out of bankruptcy. More realistically, probably because the trustee was going to take over. In Chapter 11 bankruptcy, there always isn't a trustee automatically appointed. You have to ask for it. And from the reports that were out there, they were having problems, creditors getting all the information regarding his assets and everything else. A trustee will fix that issue in 5 seconds. Oh, let me switch here on my screen. So in 5 seconds, that gets resolved. Now, that's why the bankruptcy was dismissed. I believe it was even dismissed voluntarily on his end. So if that's the case, the creditors could go forward. Doing what? Seizing assets. They already tried to do that with the condo in New York, which by the way, these donations keep coming in, but he has a condo in West Palm or Palm Beach worth like $2 or $3 million. That condo was used as the argument as that's where he resides because that's where he does his podcast from, which he gets paid for, I'm sure. So with that podcast, they were able to establish Florida residency. It's kind of a stretch, I think, but it was just basically an agreement. And the New York condo will be lost. Now, I've written about that as well. Why did they go forward and say that Florida was his residency? Don't we know him as the mayor of New York and everything else? Sure, it doesn't mean he can't relocate, etc. But Florida has unlimited homestead exemption. So a $2 or $3 million condo is 100% protected. I don't know what the exemption is in New York, but it's not fully exempt. So let's give up the one in New York and say we just live in Florida because that will protect him financially. So it's the right move. I can't criticize that. But let's go over some of the stuff as well. So I mentioned the podcast appearances. He owes over $1 million in taxes. Now, the fact that these creditors, the poll workers, were able to seize his bank accounts first, that doesn't mean that the city of New York, that he owes approximately 265,000 to, according to the latest reports, and I think it was like a little over 750 for federal taxes. They could garnish your wages. They can seize your assets. Trust me, it happens to debtors all the time. Now, here's a better question. Doesn't Giuliani know that the next step is to collect on that judgment? I would have to assume so. He is a lawyer, and he was a former chief at the Southern District. That's big time there. That's not the minor leagues there. The only the best of the best end up there. And imagine running the entire office. So he was also the mayor of New York, but he is also a lawyer, disbarred, of course, as we now know. But with that in mind, um, he would know that the next step is to freeze accounts, freeze his bank accounts. So to now be tweeting they're prohibiting him from working, bank accounts getting garnished, or wages being garnished, or assets being frozen or seized like a bank account, in no way correlates with they're trying to prevent me from working. Quite the opposite. They would want you to work so that they can collect on the judgment. The last thing a creditor wants is for you to stop working so they can't collect. The idea is work, go make more money so we can get paid back, most, some, all, depending on the facts of the situation. And by the way, when your wages are going to be garnished or your assets are going to be frozen or seized or whatever, it's not like you don't know. It's not like it's a big surprise that all of a sudden you wake up and say, hey, what happened here? We're talking about the legal process. And the legal process means they have to file document, they have to get a judgment, they got that, and then file the documents to proceed to garnish wages or to seize accounts. Why? Because you're entitled to due process. Due process allows you to counter that. So maybe your counter is whatever. Some states, for example, head of household is a reason not to garnish wages. So if that's the case, you say, oh, wait a minute, they're going to garnish my wages. I'm a head of household. Let me go ahead and file an exemption to this. So maybe they can't garnish your wages, but they can seize other assets. So just think about that. The whole thing is comical, to say the least. We are talking about lawyers involved here, and everyone's acting surprised because a bank account was frozen. And again, bank accounts have nothing to do with you working. Creditors want you to work. They prefer you take 20 jobs if possible, just so that they can get paid and continue to garnish wages. So, at the end of the day, people are donating. It's their money. They can do whatever they want. They can throw it out of the window of their car. Just don't do it somewhere where people get injured. Then you have liability issues. You can burn your own money. You can do whatever you want. But think about it. If you're facing situations financially, where do you get help from? Is anybody, setting up accounts and collecting money from you? Probably not. But that's what I find the whole thing that's comical. Not only should Giuliani and his lawyers know the process, and trust me, I'm sure they do. The reality is that there's now this situation where, I guess, like playing victim. I can't believe they're coming after my bank accounts. It's what creditors do. Every bankruptcy lawyer has a long list of clients who's had their wages garnished, liens put on their property, liens put on their cars, homes, freeze bank accounts. And when they love to freeze bank accounts? More or less around tax season, when they know that money rolls in and they say it's time to seize a bank account because now there's 4,000 more in it, 4,000 more dollars in it. So the whole concept is not surprising. I think it's, you know, use whatever word you want, but to not understand these processes is just, uh, you know, either voluntary ignorance or whatever you want to call it, because there's no way people do not understand, because everybody understands that when a creditor has a judgment against you, they're going to collect. And then the only question is clients always have is how much can they collect, where can they collect, when will they collect, etc. But to pretend to know that creditors can't seize assets, I mean, come on, that's the whole point of creditor debtor law. You signed a contract, you said you were going to pay X amount. In this case, there's a judgment. Doesn't matter where it's defamation of character, doesn't matter that it's a car accident. It is a judgment, no different than a credit card judgment. And by the way, I've discussed this before. The defamation of character, chances are that wouldn't be included in bankruptcy. That is a whole other process, which I talk about in another link about the adversary process. Typical negligence types cases, like I crash into your car. That's negligence. That's going to be wiped out in bankruptcy. Me seeing you and saying, oh, look who it is, I don't like this person, slam into them at 50 miles an hour, that's not negligence. That is intentional. We call that an intentional tort, an intentional act, and that's not going to be covered in bankruptcy. Defamation is considered an intentional act. So that alone probably was not going to get wiped out in bankruptcy. That was an issue that they were already discussing to move forward with that, and they didn't because ultimately the bankruptcy got dismissed. But again, when the bankruptcy is dismissed, you lose the protection of the automatic stay. The automatic stay is what protects everybody who files for bankruptcy, that prevents creditors from moving forward. No more creditor calls. None of that could happen once a bankruptcy is filed and remains pending. The automatic stay is so powerful that it even protects co-debtors, for example, co-signers. So if you're 3 months behind on the car and you file for bankruptcy to save it, let's say chapter 13, you can't be harassing the co-debtor as a bank or as a creditor or a lender saying, give me the money. It's like you file for bankruptcy. The automatic stay even protects them. So keep that in mind. All right. So any questions, as always, feel free to reach out to me. Thank you, everybody. Have a good rest of your week. And if you have any questions on credit or debtor law, let me know. It's pretty simple. They will freeze bank accounts. Doesn't matter if you're Rudy Giuliani, Alex Hernandez, or Joe Schmo. All right. So if you're in that situation, it's time to take action. Take care, everyone.